Welcome. This is Kelly McLendon, Managing Director of CompliancePro Solutions. Today I'm going to talk about two important topics and how they relate to each other: the HIPAA Notice of Proposed rulemaking and the information blocking rules. The HIPAA Notice of Proposed rulemaking syncs with the 21st Century Cures Act. That's the information blocking rules and interoperability rules. The HIPAA Notice of Proposed rulemaking comment period has been extended to May 6, 2021. They issued the Notice of Proposed rulemaking in December of 2020. With the Biden administration coming in, they've expanded the time frame for the comment period. What this means is that they won't actually get a final rule issued until later in 2021 probably. So for now, what you're going to see about HIPAA proposed changes is all it is, proposed. We haven't yet gotten the final rules, but we are sure a lot of this will turn into some kind of final rule because it does help sync HIPAA with the information blocking rules, which, by the way, go into effect on April 5th, 2021. So per the proposals from the Office for Civil Rights, this Notice of Proposed rulemaking is supporting HHS's regulatory sprint to coordinated care. Specifically, the proposals in this Notice of Proposed rulemaking amend the provisions of the privacy rule that could prevent or present barriers to coordinated care and case management, or impose other regulatory burdens without significantly compensating for or offsetting such burdens through privacy protections. So trying to find reasons to synchronize HIPAA with this new information blocking rules. They are very interwoven together, and that's their reasons for why. So they have put the Notice of Proposed rulemaking together after they gathered information from professionals in the field for quite some period of time, a couple of years. So this has been a long time coming. Now, the modifying provisions in the individual's right of access to PHI is impacted in this new HIPAA NPRM. And they're going to do things like strengthening individuals' rights to inspect their PHI in person, which allows individuals to take notes or other personal resources to view and capture images of their PHI, shortening the required time frame for getting information back to a patient for a request for their information for their PHI, or what they call EHI now. They're shortening it from 30 to 15 days. That's what they'd like to do. I'm pretty sure they're going to do that. But again, until the final rule, nothing has changed. They want to clarify the form and format required for responding to individual requests for their PHI. So they want to make sure that there's little latitude for how you respond with form and format, that either you can agree or not agree, but that they'll have the steps lined up for you. This again plays in the information blocking rules, which get invoked whenever you are not going to fill a patient's request for their PHI. Requiring covered entities to inform individuals they retain the right to obtain or direct copies to a third party when a summary of PHI is offered in lieu of a copy, reducing the identity verification burden on individuals accessing their rights, which means you will probably be having to ask less questions and being somewhat less sure of who the individuals are that are requesting their access rights. Creating a pathway for individuals to direct the sharing of PHI in an EHR among covered healthcare providers and health plans by requiring the covered health providers to submit the individual's access request to another healthcare provider and receive back the electronic copy. So trying to make it easier for the patients to ask their physicians to get the copies for them, and the physicians then that are requested of the records have to send them out. All again will fall under the information blocking rules too. Requiring covered health providers and health plans to respond to certain record requests received from other healthcare providers. Again, wanting to make sure patients can ask their physicians to get their records, and then their records should be coming back to those physicians. limiting the individual right of access to direct transmission of PHI to a third party to electronic copies. So if you're going to have to ask your physician to send copies to someone else, a third party of some kind, it's going to limit that to electronic copies. Paper copies won't be included in that. Specifying when PHI must be provided to an individual at no charge, and again, that's electronic PHI, not paper. Amending the permissible fee structure for responding to requests to direct records to a third party, and requiring covered entities to post estimated fees on their website for access and disclosures with an individual's valid authorization, and upon request, individualized estimate of fees for an individual request for copies. This is a very big deal for the release of information part of your practice or your organization. So we got to be very careful with what changes are coming down from HIPAA, because some will be impacting processes such as patients' right to access and your release of information processes. They're going to amend the definition of healthcare operations to help with individual level care coordination, and again, sharing of the information so that care coordination and case management can more easily be done under the rules. They're going to have an exception to minimum necessary. That's again in line with this care coordination and case management. They're going to clarify the scope of covered entities' ability to disclose PHI to social service agencies and other community-based organizations. And they're going to replace the privacy standards that permits covered entities to make certain uses and disclosures of PHI based on their professional judgment, with a standard permitting such uses and disclosures based on a covered entity's good faith belief that the use or disclosure is in the best interest of the individual. That changes the standard a little bit into privacy and is going to then make covered entities a little easier for them to go ahead and share and use information for care coordination and case management type scenarios, maybe some other ones too. So it does change the standard to make it easier to make some data sharing. Going to expand the ability of covered entities to disclose PHI to avert a threat to safety or health when harm is serious and reasonably foreseeable instead of the current stricter standard. Eliminates a requirement to obtain an individual's written acknowledgement that they got a copy of the Notice of Privacy Practices. That should make a lot of people happy. Modifying the content of the requirements to clarify individuals' rights with respect to their PHI. This is basically saying they're going to want some updates to your Notice of Privacy Practices to clarify with respect to their PHI how to exercise those rights. So expect that when the new rule comes, there will be a requirement to modify our Notice of Privacy Practices. Expressly permit disclosures with telecommunications relay services and a couple of other areas that they're going to be expanding into. Thank you for your attention today, and if you have any questions, please feel free to reach out directly to me. Here's my contact info.